All right, please be seated. And we're now into our criminal docket. It looks like y'all are ready, huh? Okay. Make sure my computer's ready. All right, counsel.
Good morning, may it please the court. My name is William Pinnell, and I represent Jose Luis RECCO, the appellant in this case. Please reserve 4 minutes of my time for rebuttal.
All right.
In this case, Mr. RECCO was convicted of various counts related to alleged sexual misconduct that allegedly occurred during a single episode at the alleged victim's home. The only evidence of guilt presented by the state was the testimony and out-of-court statements of the alleged victim. The alleged victim's allegations against Mr. RECCO were not corroborated by any eyewitness testimony, scientific evidence, or forensic evidence. Mr. RECCO never made any statements admitting that he committed any of the alleged act. He has maintained his innocence from the outset of the case. As a result, at trial, the state's entire case was based upon the credibility of the alleged victim. And during her testimony, she was uncertain about the details of the alleged incidents and made statements that contradicted her own trial testimony and in statements that she had made in pretrial deposition. It's our position that Mr. RECCO is entitled to a new trial because the trial court abused its discretion by, one, precluding Mr. RECCO from cross-examining the alleged victim with prior inconsistent statements she made during her videotaped deposition, and two, by denying Mr. RECCO's motion to declare the alleged victim incompetent to testify.
Didn't the trial judge conclude, as far as the statements that were made at her depo, that the differences weren't material, or that they were on collateral matters?
That was the trial court's conclusion. It's our position that that conclusion is incorrect and constitutes an abuse of discretion under the case law from both the Florida Supreme Court and this court.
Which case do you think is your most helpful on that point?
Sure. In the Daquil case, 929 Southern 2nd 1139 from this court in 2006, this court found that it was reversible error where the trial court prohibits cross-examination when facts sought to be elicited are germane to the witness's testimony and plausibly relevant to the theory of defense. Here, the theory of defense was the alleged victim was not credible because she could not give a consistent account of what she allegedly saw, what allegedly occurred, and how the defendant appeared on the date in question. In that case, this court also said the Supreme Court has long held that cross-examination is not confined to the identical details testified to in chief, but extends to its entire subject matter and to all matters that may modify, supplement, contradict, rebut, or make clear the facts testified to in chief. It's our position that the 4 inconsistencies that were proffered by trial counsel all are relevant and material to the alleged victim's credibility. The trial court seemed to believe that something is only material if it's directly related to the elements of the offense. It's our position, and I think the case I just cited supports the idea that anything having to do with the circumstances under which the offense occurred or the elements of the offense would be relevant to the credibility of the alleged victim. Here, the alleged victim at trial said that her and Mr. RECCO walked into the bathroom together. That was contradicted by her deposition testimony where she said she walked in on Mr. RECCO while he was sitting on the toilet. It's our position that those are circumstances under which these alleged events occurred, and they call into question the credibility of the alleged victim's testimony because she does not recall or can't keep it straight in her mind what actually occurred or what she says occurred. Same thing where first she says at trial she did not know whether she had explained the rules of the joke game to Mr. RECCO. She had previously testified she for sure did not explain those things. So those are inconsistent and again go to the circumstances under which these offenses allegedly occurred. Third, at trial, the alleged victim testified that Mr. Recco's penis looked like an oval, but in her deposition, she'd previously described it as looking like a moon, 4 circles, an ice cream cone, and a circle. So we have some inconsistencies there, and that particular inconsistency goes directly to an element of the offense in count number 4, which was lewd exhibition, where it's alleged that Mr. Recco displayed his penis to the alleged victim. The fact that she described it inconsistently suggests that she may not have actually seen it, and that's why her description is all over the map. Not only was her testimony inconsistent as to what his penis looked like, her mom testified that Samantha described it as something long with 2 balls. So we have 4 or 5 different descriptions of the body part that supports count 4 of the information that were not allowed to be permitted as cross-examination to undermine the credibility of the alleged victim. So it's our position that the judge's conclusion that they were not material and they were collateral is not supported by the Dakhil case or any of the other cases cited by us in the briefs. The Garcia case from the Florida Supreme Court, 4 murder convictions were reversed. The cross-examination of a witness about his relationship with the defendants was precluded. That's not directly related to any specific element, and they said that was error. So the trial judge's restricted definition of material here was incorrect under the case law and precluded full and fair cross-examination that is permitted under the Florida and the United States Constitutions. The cases from this court have over and over have said that deprivation of full cross-examination is particularly harmful when it's the key state witness. The only witness in this case, the only evidence of guilt comes from the alleged victim. It's either her statements at trial or her out-of-court statements introduced through hearsay testimony. There's no other corroborating evidence other than the alleged victim, so her credibility is the state's entire case. So when you improperly preclude the defendant from attacking her credibility by limiting cross-examination, it's particularly harmful when it's the sole and main witness the state is relying on. And that's supported by the Garcia case, the Dakhil case, and the Elmer case from this court in 2012, where this court said a criminal defendant is entitled to wide latitude when cross-examining a key prosecution witness. Again, the alleged victim is pretty much the only witness in this case that matters.
The defense is allowed to impeach even with collateral matters, aren't they?
They are, Your Honor. They are, Your Honor. But it's our position that these matters are not even collateral. The defense lawyer in this case wasn't asking the alleged victim who won the Super Bowl this year and contrasting it if she gave, one day she said the Giants, one day she said the Rams. They were asking about specific circumstances under which this alleged abuse occurred. This all allegedly occurred in a short period of time in a bathroom. The questions that were proffered had to do with when they entered the bathroom, how they entered the bathroom, where the people were in the bathroom, and what the alleged victim saw, and whether there was inconsistencies in that. And clearly that's admissible to show that her credibility could be called into question in this case. This court in the Gamble case from 2012, when talking about cross-examination, says it's the specifics, the details, the nitty-gritty of life that proves or disproves generalities and which permits effective cross-examination. It's undisputed on this record that despite defense counsel's repeated efforts, that the trial judge precluded him from doing that and deprived Mr. Recco of his right to a fair trial. The alleged victim's inability to provide a consistent account of the circumstances under which the alleged abuse occurred, and her inability to provide a consistent description of the body parts on Mr. Recco she saw, are relevant material to her credibility and whether she had fabricated the allegations against Mr. Recco. His defense was, she's making this up, she can't even keep this story straight, and he made efforts to prove that through proper cross-examination under the rules, proper cross-examination under the Constitution, and the trial judge precluded that.
What of the trial judge's comments that it's kind of obvious that her story has changed over time, therefore, You may not be able to show it all, but it's clear she's changed her story. You can argue that.
Well, the important fact is that the cases have said that use of prior inconsistent statements, and this is the Elmer case, use of prior inconsistent statements is one of the main ways to attack the credibility of a witness. And up until that point, and he was never allowed to do that. So I can't imagine a more powerful way of discrediting a witness than having him testify live about a fact and then showing the jury the video where that witness testifies directly contrary to that. So the trial judge in this case deprived the defendant of using the most powerful impeachment evidence that was available to the defendant. There's no basis for that in the law. There's no basis for that in the Constitution. So Mr. RECCO was deprived of a fair trial to which he was entitled to under both constitutions, and I'll reserve the rest of my time for rebuttal.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. First of all, let's talk about the procedure here, because the defense asserts that the trial court precluded him from cross-examining the victim, and that's not true. He cross-examined the victim extensively, and then when he went up to start laying a foundation for impeaching her, the trial court, he asked to approach the bench, and they said, well, what are you going to do? And the trial court said, generally we require that so that the witness has an opportunity to explain why the testimony is different. I'm not going to do that in this case because we're talking about a 6-year-old. So I'm just going to let you put in inconsistent statements without laying the foundation, because the prosecutor was like, well, he has to, confront the witness and give her an opportunity to explain why her deposition was different. And the court said, I'm not going to make you do that. We're just going to talk about what's different with the witness out of the room and the jury out of the room, and then you can just play those snippets because they had a video deposition. They never transcribed it. So that actually made it easier for the defense. It didn't preclude cross-examination. It made it easier because they eliminated that foundation and didn't require the defendant to get up there and confuse this 6-year-old anymore. As far as the parts of the deposition that defense counsel actually wanted to play, the trial court correctly said you don't get to impeach with every single thing that's, tiny differences. That's not how impeachment works. The Florida Supreme Court has said a prior inconsistent statement has to directly contradict or be materially different from the testimony at trial, and it has to involve a material, significant fact rather than mere details. So there's 4 areas here where they wanted to impeach this child. The first one was entering the bathroom. At trial, she said that they walked in together and the defendant sat on the toilet. She also said at trial the defendant didn't ask her to come in there. She just went in there. In her deposition, she apparently said that she walked in and the defendant was sitting on the toilet. In her CPT interview, which was played for the jury, the child said that the defendant was sitting there not going potty when she walked in. So they already had an inconsistent statement on that very matter. She also told her mom that she walked in on him when she first disclosed the abuse. So there were inconsistencies that were revealed to the jury. They didn't need to play the deposition. That would have been cumulative. And most importantly, we're talking about an insignificant detail. She didn't say in the deposition, yeah, he dragged me in there, by my hair. She didn't testify to that once. And then in trial say, yeah, we walked in together. I mean, we're talking about the timing of who walked in first, essentially, and that we would submit that there's no abuse of discretion in finding that that's a collateral matter.
Well, if it was entirely collateral, then why did the state introduce it in its case in chief? Why was it relevant who walked in with whom, who went in first? You introduce it during your case in chief. Well, you introduce it with a CPT statement. So it wasn't collateral for that.
They were setting up how they ended up in the bathroom.
Right, but if it wasn't collateral for that, why is it collateral when they want to point out yet another inconsistency or alleged inconsistency?
Because they're asking the child how they ended up in the bathroom, and that, not, again, whether she walked in on him when he was sitting on the toilet or they walked in together and he's sitting on the toilet, what's the difference? I mean,
Well, I don't know,
it's
but
not a big
apparently the
difference.
state thought it made a difference because you asked those questions of the child.
The state asked how they got into the bathroom.
Right. And so I assume that the state felt that it was relevant and somehow material, and it was asked in the CPT interview. I guess my concern here is it does seem like there may be some heightened need for a vigorous cross-examination and the opportunity for impeachment when the only evidence is one witness says this, and you've got a witness who, admittedly, it's very difficult to cross-examine a 6-year-old or examine a 6-year-old. And you know, it's a tough thing. And if there was a ton of other corroborative evidence, you'd probably say, well, if it's error at all, it's harmless. And I'm not saying it's error, but it does seem to me that there may be some heightened need for a vigorous examination when the only witness is not subject to impeachment.
But she was subject to impeachment if she had said something materially different. If she had said at the deposition, he never touched my butt, and because she testified at trial a couple of times that he did, that's, of course, that can come in. But if she, and even if she had said, you know, at trial she said, we walked in together, and if she had said in the deposition, he pulled me in there, or something that's completely different, you know, materially different, directly contradicts it, then of course that would come in. We're talking about, one time she says they went in together and he sat down, one time she says I walked in and he was sitting down. I mean, that's not a big difference, especially for a small child like that. And again, the standard here is abuse of discretion, and the trial court saw the testimony, heard the hearsay evidence that came in, and found that this was collateral, and we admit that that's not an abuse of discretion.
Is one of the jury instructions that was used that the jury should consider whether or not the witness was able to maintain or relate a consistent story?
Right, yes, it was, and
Well, but don't tell us about small inconsistencies, only about great big ones.
but they heard about the small inconsistencies. Just looking at this one out of the 4, they did hear about that, because in her CPT interview, she said, I walked in and he was sitting on the potty. So they did hear that she couldn't keep those small details straight. And if you look at the cross-examination of the victim, she could not keep the small details straight. She couldn't. I mean, we admit that. He asked a lot of questions about the sequence of events and the joke game and the spin game. Okay, well, when did the touching occur? And that changed throughout the cross-examination. He touched my butt before this. Well, no, it was after this. I mean, she says in one part, she contradicts herself within 2 questions of each other. She did not get the details straight. She did not tell a consistent, detailed story. But you know what she consistently said? These are the things he did to me. He touched me. He masturbated in front of me. He wanted me to kiss his butt, but I just used my hand. Those things never wavered. She said the same thing to her mom. She said it in the CPT interview, and she said it at trial. And nothing in the deposition touches those elements. The second part is this joke game. The child said that they played a game where they told a joke, and if they told it wrong, they had to take their clothes off. She said that at trial. She said that in her CPT interview. She said that to her mom, and she said that at the deposition. The change that was not admitted from the deposition is whether or not she explained the rules to him. She said at her deposition that she didn't explain the rules to him. At trial, she said, I don't know if I explained the rules to him or not. And then they said, well, but he played it, right? Yes, he played it. Okay, this is not a, you know, tic-tac-toe or a game that everybody knows. So obviously she had to have explained the rules to him at some point, but she couldn't remember doing that. Again, a small detail that was already brought out at trial, because in the CPT interview, she said the defendant didn't listen to the rules, and she said that she did tell him the rules. So we do have different stories about that they could argue to the jury, inconsistent statements on a very minor detail. Again, if she had said at trial we played the joke game, and at deposition, she said, he came up with this joke game, and he told me to take off my clothes. Of course that should have come in, but that's not the kind of impeachment we're talking about here. We're talking about a very collateral matter. The third item that they wanted to impeach her with is whether or not it was their policy at home to leave the door open when they went to the bathroom. At trial, they said they closed the door in their house when they use the bathroom. At deposition, she said they keep the door open. Those things directly contradict each other. We would submit that that is a purely collateral matter. It has nothing to do with anything. Because again, she never said the defendant dragged me in there. She said, I walked in on him. Whether or not the door was open or closed, we would submit has nothing to do with anything. As far as describing his penis, we're talking about a 6-year-old here. At trial, she called it an oval. She said it was different from the kid that she had seen at school who had pulled his pants down, and she said it bounced. When she talked to her mom, she said it was long with 2 balls. When she talked to the CPT interviewer, she said it was a circle and then a P. It had a little circle at the end. It bounced around, and there was a hole at the bottom to go pee-pee. None of those words are exactly the same. They all describe a penis pretty well for a 6-year-old. Now, at deposition, she apparently said it was like a moon, 4 circles, an ice cream cone, or a circle. We would submit that considering this is a 6-year-old, she used different words to describe the same thing. Those are all descriptive for a small child of a penis. So again, we're talking about using different words here. If some of this should have come in, we would submit that it was harmless error not to, given the nature of what they wanted to impeach him on. The fact that that the child did make contradictory statements on a lot of the details of the story, but again, the thing that she stayed consistent about is that the abuse happened and what exactly that abuse was. That never changed. And so we would submit that even if some of this should have come in, it would not have made a difference. This was not a child who told the same details throughout her testimony even. She changed her story. She could not get sequences right. She's 6 years old. So we would submit that the trial court acted within its discretion in not playing this video for the jury on these minor inconsistencies that would have been cumulative at best, and we would ask the court to affirm. Thank you.
May it please the court. Certainly, it's difficult to cross-examine a young child, but respectfully, the Constitution and the rules of evidence still apply. You know, just to discard them because there's a young child victim. Under this court's case law and the Florida Supreme Court's case law, a defendant's entitled to a full and fair cross-examination, not just some limited cross-examination the trial judge determines is enough. That's the Daciel case. The jury gets to hear the inconsistencies, and then under the circumstances, including the fact that we have a young child victim, determines whether they matter. The judge doesn't get to cut the defendant off and say, you've had enough. The jury gets to decide whether it's enough or not. We weren't in the jury room. We don't know if these 4 additional inconsistencies that would have been shown on video would have made a difference. What we do know is there was no basis under the law to preclude it. He was never allowed to play the inconsistent statements for the jury. We disagree that they're not material. Again, under Daciel, this court has said that you can, on cross-examination, credibility is always permissible and it can extend to the entire subject matter. The idea that the circumstances under which the 2 individuals walked into the bathroom is not relevant to the entire subject matter defies logic to me. I don't understand how that wouldn't be relevant, and her inability to recall the details of who walked in first and of inability to be consistent of her description of a body part that is an element of the offense under count 4 is relevant to show that her story is not credible and that it's fabricated because she can't keep it straight. So, and finally, the state's argument that this is harmless is rejected by every single case cited in our briefs from this court where the only evidence is from the alleged victim. First, the Florida Supreme Court in Garcia, they found no harmless error where cross-examination was improperly limited because there was no physical evidence linking the defendant to the murders, and the witness, the Rivera witness in that case, was a linchpin of the state's case. His credibility was critical to the strength of the state's case. Obviously, the alleged victim is the only evidence in this case, and her testimony is critical to the state's case. There's no way under those circumstances the state can meet its burden to show beyond a reasonable doubt that there's no chance it affected the verdict in this case. Same thing in the Elmer case from this court. Victim's credibility was crucial to the state's case. Restriction of cross-examination is not harmless. So, Mr. RECCO was deprived of a full and fair cross-examination, not just on the limited cross-examination the trial judge determined was appropriate. It is an abuse of discretion, and all these inconsistencies are relevant to credibility and should have been considered by the jury. So we'd ask the court to reverse the convictions and remand for a new trial. Thank you.
Thank you.